introduction into the lecture of today. I have been told he is a very tall man, but he's also a practicing lawyer, a great human being according to his friends, and he's ready to impact knowledge to us. Ladies and gentlemen, welcome Kelvin Walumbe to the stage. He's very tall, guys. Wow. Kumbe mimi ni mfupi.
Thank you, sir. Good evening. You know, I have never attended these lectures. And if this is a hype, then I have a beef against my friend here who has been coming here. And he'll have to buy me some beer. Today he's the one covering the bill. So, when I was approached by Keith to come and give a lecture, I thought about the classroom lecture sessions that I used to give some time back. And I was very stressed. If you look on that table, in fact, I've carried acts of parliament with sticky notes and paginated and everything. But I've come here and I'm very relaxed because this is some sort of interactive session that is amazing. So keep it up, drunken lectures, keep it up. Now recently, you guys, you saw on the news that the directive by the Communications Authority, to close down or to lock those TV stations and radio stations that were airing demonstrations live was declared unconstitutional, correct? Now that relates to the Computer Misuse and Cybercrimes Act. In this room, we have the person who actually drafted the case within 2 hours, filed the same, and we got orders before evening. That guy is called Joshua Malizo Nyawa from Katiba Institute. Here. Now, I am litigation counsel at Katiba Institute. On this table are my colleagues. And Katiba is just the constitution in Swahili, sindio? And wherever we go, we don't walk empty-handed. We walk with the constitution. So perhaps those people who are here and emerged winners might be lucky today, Joshua. Or perhaps the organizers of the drunken lectures will be lucky. So it's a pocket constitution. Wherever you go, the constitution goes. Wherever you go, if you are given this constitution, wherever you go, it goes. So who will take the constitution on behalf of? I want a member of the very well. And as I said, you should be working with that constitution everywhere you go if you are given. As I am, I have a constitution on my body. If you ambush me, I will start quoting for you the constitution, correct? So, just to kick off, there was a lot of fear about marriage because you guys think that once you marry, if you want to divorce, you have to stay with each other for 3 years. And there was another fear that in case you want to separate, the separation must last for at least 2 years before the divorce can be concluded. But fear you not, those provisions were declared unconstitutional by the courts. If you marry and today and tomorrow you feel like this person is not my type because they smell some kind of way, you can go and file a case and go home. Now, to the Computer Misuse and Cybercrimes Amendment Act, I just mentioned the power of the Communications Authority to shut down radio stations and TVs that were airing demonstrations live. Now, there is this amendment to the Computer Misuse and Cybercrimes Act that gives similar authority to the committee. There is a committee established under the Act Now, how this amendment affects, you can see the first part. The committee can now give a directive that a website, or be it Twitter or a Facebook account, be shut down if it is proved that, you can just read, if it is proved that, are you guys with me? It can shut down if it is proved that, yes? Well, so if it is proved that the website or the site is publishing information that might be injurious to a person, that might be showing child pornographic material and all that. Now what this does is that before a decision is done, there must be due process of the law. And what is due process of the law? Is that if there is a complainant, they make the complaint, and then there is an investigative authority, or the person who receives the complaint investigates. Then, if there is grounds, they file a case in court. Then a decision is made by the court whether that site should be shut down or not. Sindio? So that there is separation of powers. There is the investigative body and there is the decision-making body. But what this provision does is to make the committee what we call both the judge and the jury. It will determine whether that website or the site has contravened the act. Then it will also take the action of shutting down that website. So we have not been told who will prove the allegation. Proved by who? Is it that the committee itself just decides that in our view, there is contravention of the law, and then they shut down the site? I am referring to the TV and radio shutdown just to show you how drastic it can be. Okay? And then we have not been told proof to what extent. So, in legal terms, there are usually several types of proof. There is proof to beyond reasonable doubt. That is in criminal cases. If you are accused of having killed somebody, the person who is accusing you has to prove beyond reasonable doubt. That is why there are different types of offenses, manslaughter and murder. If they prove beyond reasonable doubt that you killed that person and you intended to kill them, it is murder. If it is just proved that you killed them but they don't show intention, then it is manslaughter. For murder, you will go in for life imprisonment, which is being commuted to somehow 30 years or below. Manslaughter, you can even serve only 1 year, depending on the circumstances, because somebody died, but you did not intend to kill them. There is also another level of proof, which is on the balance of probability. That applies in civil cases. If there is a contract between you and somebody, and you accuse them of having pilfered your money, you just need to show, on a balance of probability, who will the court believe, you or the other person? Then you win. Then on suspicious grounds, if it is just suspicious, can the proof to the committee be on suspicion? Most probably, yes. Okay. Now, it is also not clear, yeah, whether the mandate of the committee will remain as it was. The act, under the act, before it was amended, the mandate of the committee was to ensure the implementation of the Computer Misuse and Cybercrimes Act, to advise the authority and all that. But here now it is receiving further duties of implementing the law without going to court. It can act on its own and shut down people's websites. Now imagine that you have a Twitter space you are having, and then somebody says that I think there's some criminal activity going on in that Twitter space. Somebody, wherever they are, they can shut it down without any legal procedure if that section remains. Now, the good news is that several organizations went to court. We have at least 7 pending cases in court, and the application of this act has been stayed until the case is heard and determined. Okay? Any questions thus far? Are we together? Are we going? Or are we coming? Mutuse? Okay. Now, there is another amendment to Section 27, which provides criminal offenses that can be committed by people. Yeah? That the amendment amends Section 27(1) to include conduct that is likely to cause another person to commit suicide. So there are several criminal offenses that have been listed under Section 27. But I picked this one out, that if you share directly with somebody, or indirectly, that's through another person, if you share information with that person, yeah, and you know or ought to know that if you share that information, it might cause that person to commit suicide, then you are committed an offense and you are liable, if you are convicted, to imprisonment for at least 10 years or a fine of 20 million shillings. Now, if you guys have been keeping up with the tabs, you realize that attempted suicide was declared, initially, attempted suicide was a criminal offense. Yes, if you attempted to kill yourself and you did not succeed, okay, you will be, if you are harmed, you will be taken to hospital, and upon being treated, you will be taken to a court of law and you will be convicted for attempted suicide. So medics said, attempted suicide is a mental sickness. By the time somebody decides to kill themselves, they have reached a certain threshold where rationality is elusive. So it is something to be treated, not something to be punished. So for you to imagine, now you can imagine in this room, maybe there are people who are bloggers or they use the internet as their source of livelihood. Now, I have just told you that should you be found to be using your site, yeah, illegally or wrongly, and then you cause somebody, or you publish information that might make somebody to commit suicide, then you will be fined 20 years. Then you decide that, now this is like taking away my source of livelihood, and I don't know your threshold of holding on, and you decide now I don't need to live any longer. Let me kill myself. You see, this is something that has to be attempted suicide. How do I know your triggers, all of you in this house? Something that might trigger you to commit suicide. How do I know what you have suffered in your previous lives? Kama uliachwa, whatever happened. So that for a mental illness, for somebody to be taken to have a mental illness, it needs a medical examination. Okay? So here is a provision which is punishing the entire public without looking at whether this public or the people who are using these platforms can actually be convicted of causing somebody to commit suicide, knowingly. Yeah? Tell me, a reasonable person in this room, are you able to look at somebody and assess whether they are suicidal or not? Are you? So that provision stands, and there are other provisions that were introduced as well. That is, if you promote cultism, if your publications are seen to promote cultism, if your publications are seen to be extremists on religious grounds, that is two extremists either on the Christian side or two extremists on the Muslim side. You can see the Shakahola things. But this provision on extremist religious dialogue has affected a specific sector of our society. Anybody who is a member of Muhuri can tell us that people who have been affected by such provisions, that is extremism and terrorism, are our Muslim brothers, mostly from the coast, Lamu, and all those areas. So these provisions are not defined. In criminal law, every provision of the law or every word has to be very specific, because it is going to affect the liberty of somebody if somebody is charged. So these provisions like cultism is not defined in this act, it is not defined anywhere. So who will determine that whatever you are doing amounts to cultism? And if you are found guilty of having committed that offense, you are bound to pay 20 million, or you rot in jail for 10 years. You see, I don't know why there are such harsh sentences, because if you do a comparison under the Penal Code or the Criminal Offences Act, or we can take that one which is the one that has brought a lot of controversy, the Sexual Offences Act, okay? If you are found guilty of defilement of a minor who is 15 years and below, you go to prison for 15 years, okay? If you are found guilty of having published something, you go to prison for 10 years. Is there a balance? So you can see how much a gag is being put onto your mouth. Anyway, that is where we are. Those two amendments are the ones that I found to be controversial in the Computer Misuse and Cybercrimes Act. Now we go to the Privatization Act. Of course, maybe I can just touch on what this is going to do. We enjoy freedom of expression that is provided in that constitution under Article 33. Whatever is being done is a limitation of the freedom of expression. Remember, everything that was being witnessed during the June demonstrations was freedom of expression. And most of the mobilization was done online, okay? So essentially, that platform of mobilization, if you are dissatisfied with anything, the main platform of mobilization is being removed. So unless now you will start using the traditional methods like smoke signals and sending athletes, we don't know how people will be able to mobilize each other, at least to push back against certain provisions of the law or certain actions of the government that they are not happy with. Now, for somebody to limit your right, yeah, under Article 24, you know, rights are provided, but they can be limited. For somebody to limit your right, it has to be justified, it has to be provided in a law, yeah, and it has to be reasonable. So if you think that 10 years is unreasonable, already the provision of the law fails the test of reasonableness under the act. At least it is provided under the law. There is this act, that one passes. It has to be justified. If the government comes and says national security is the one that is justifying is to pass this, or the privacy of persons and all that, is that justified? If it is justified, is it reasonable in a democratic society? Kenya is a democratic society. So perhaps just reflect on that. As I said, there are several petitions. The Law Society of Kenya filed a petition. ICJ Kenya, Article 19. The Kenya Human Rights Commission and others, they moved to court and they got interim orders stopping the implementation of that act until the case is heard and determined. So some of those things that I have raised are the ones that have been raised in court, and we will be waiting for the court to pronounce itself on it, whether they are reasonable or not. Now, to the Privatization Act, this was not an amendment, but rather a repeal of the entire act. Repeal means the act that was there before was completely removed, and a new act was enacted. Remember that the Privatization Act 2023 was contested in court, and most of the provisions of that act were declared unconstitutional. It was not very feasible to implement the act as it was. So the parliamentarians went back to at least try and make amendments and see whether they will come back with a better version of the act. But having looked at it, there are several problems. First of all, somebody said, if I want to sell the country, I'll just take a few cronies of mine, put them into office where they can make decisions and enable the selling. Sindio? Now look at the appointment of members of the Privatization Authority. The appointment. The president appoints the chairperson of the Privatization Authority. Then the cabinet secretary will appoint 6 members of the authority. Now, who appoints the cabinet secretary? Who is appointing the chair? And the cabinet secretary is appointing. So where is the chain of answers? Who is calling the shots? So do we go back and start? The president appoints the chairperson of the Privatization Authority. Okay? Then the cabinet secretary appoints 6 members of the Privatization Authority. They have said through a competitive method. They have not outlined how. Okay? Now, we are saying, where is the diversification? They are just saying, as long as he looks at gender, the president looks at regional balance and marginalized groups, then it's good to go. But when we look at implementation, when you look at people being answerable to who, then it is unidirectional. If the president tells the cabinet secretary, I want Zoya Sugar Company privatized, will it be privatized or will it not be privatized? Because once he calls the shots, there is nothing to bar the decision of the president from being implemented. In normal circumstances, these appointive positions ought to have parliamentary vetting. You see, we are going to deal with public assets. Somebody mentioned the Kenya Ports Authority. If we decided to privatize the Kenya Ports Authority today, how many people are being affected? Because you look at the chain of the flow of those goods in transit from the port up to the border. Right from the port, yeah? those people who are employed in the port themselves, up to that mandazi hawker who will give that driver of the truck some tea in the morning when they are sleeping at Bukembe or somewhere. So when this decision is being taken, now on to my second point, the authority, if it decides that it wants to privatize a certain asset, they have to come up with a program. The authority comes up with a program, presents the program to the cabinet secretary. The cabinet secretary presents the same to the cabinet for approval. Okay? And then, after that, the proposal can be taken to Parliament for approval. Look at the sequence of events. The authority, which we have said is entirely appointed by the President because of that chain of answerability, comes up with a proposal, submits the same to the Cabinet Secretary. The Cabinet Secretary goes and submits that one to the Cabinet for approval. Then it is taken to Parliament for debate and approval. That is the National Assembly, not even the Senate Assembly. Now, I talked about privatization of the Port of Mombasa. If it is to be privatized, how many entities are going to be affected? Do we have a community that relies on that port? Do we have a county government where that port sits? Does the county government earn revenue from that port? If it is privatized, is the county government going to be affected? Who exercises oversight over the county government? The Senate, okay? Has the Senate been included anywhere in this process? We are talking about the executive and the legislature. And then we have a national legal advisor in the name of the Office of the Attorney General. Sindio? Privatization is essentially carrying out, like somebody mentioned, feasibility studies, and there are some legal aspects of it because there will be an agreement between the entity that is privatizing the asset and the private person that is buying. Okay? Now, who is supposed to verify the agreements that the national government drafts? Who is supposed to verify? The Attorney General. Have you seen anywhere the mention of the Attorney General in that sequence? So who will advise government whether this process that we are undertaking for privatization is correct or wrong? Who will advise the government whether the process, whether Kenyans are being pilfered or not? So this is an executive-driven process. With Parliament, that is by Parliament, we just mean the National Assembly, being a rubber stamping body. Now, I want you to look at the Act. It is drafted in simple terms, because a lot mention very many things under the Act. But I would want you to go through it and see where we are headed. Because this Act was adopted after scuffles with privatizing the Kenya pipeline. The Kenya pipeline. There are issues to do with public participation. Okay? The authority, once it identifies an asset that it wants to privatize, the Act provides that it will have consultations with people who will be affected. So entities who will be affected include employees, people who own shares. Okay? Now what about you, the common mwananchi? We have been talking about public participation, and some of the actions of government have been struck down by courts because of public participation. Now this Act provides procedure that has to be followed in that public participation. You are the public. We have seen that if the port of Mombasa was to be privatized, it will not only affect people in Mombasa, it will affect people at the border in Busia or Malava, okay, who rely on those goods. If somebody privatizes and they decide that we are not going to use the roads, we are going to use SGR, or we are going to use the old railway to transport these goods, what do you have to say as the public if you have been relying on revenue from that business? Now, public participation comes in when you can access information. Okay? Public participation can only be helpful if you access information beforehand. Information regarding privatization can only be published, one, upon the conclusion of the privatization process. That is, if there is a proposal, then upon conclusion, the proposal will be gazetted if the National Assembly approves. With regard to agreements between the privatizing entity and the person buying, what have we been relying on? We have been relying on whistleblower information to know what is happening. That goes with the Adani deal, Apoko Airport, and the contract between Adani and Ketraco on the transmission of electricity. Okay? We were relying on whistleblowers. So right now, there is a clause providing for punishment. It is a criminal offense for somebody to share information, that is insider information, before the contract is concluded. The contract or the agreement can only be published after it has been signed between the privatizing entity and the cabinet secretary and the person who is buying the asset. So that you, who is supposed to know why KPA is being privatized, you, who is supposed to know how much it is being bought for, how long it is being sold, yeah, and how much the government will be getting in terms of tax or all that, you will only have to access that information after the deal is sealed. Of what use will that information be to you for you to participate in that process of privatization? Now, you look at, again, I urge you to look at the Act because it is written in simple terms. I'm only touching on a few things that can excite your emotions. Because we have very many private entities. You look at Tanzania, they are trying to get back their assets from private hands back to the government. Okay? You look at Kenya, we are trying to get assets from the government to private individuals. Okay. One of the reasons that have been given for the passage of this act is so that the government can raise revenue. Okay? What is usually wrong with the current assets or current public assets in terms of raising revenue? And let me ask, if we have a publicly owned company, where does it sit? It sits on public land. Okay? How is public land supposed to be converted from public to private? There is an entire process involving the National Land Commission. If you look at that act, okay, there is no provision where the National Land Commission is going to be involved in the process of privatization. Some of the public assets sit on land that is owned by the community but held in trust by the county governments, okay? Which means if an asset sits on community land, in most cases, not registered, but owned by the county government. Have you seen anywhere where the county government is involved? Have you seen anywhere where the Senate is involved? Now, after the asset is disposed, let us talk about an asset that now rests in a county government, like Nzoia Sugar Company, for example. You saw recently it was given to an Indian. What is his name? Rai. Yeah? Now, Nzoia Sugar Company sits on a very huge tract of land that is owned by the community. People were moved from that land in the 1978, and the land is held in trust by Bungoma County right now. So, there are some benefits that were being accrued by the community from the land or from Nzoia Sugar Company while it was a public entity. Okay? There was some lease money that was being paid to the county. And people were allowed to go into the land and harvest, I think, cut some grass and feed the animals and all that. But what I'm driving at is, after privatization, the funds that come from privatization are deposited into the consolidated fund. That is a government. The consolidated fund is run by the government. So if Nzoia Sugar Company is privatized, all the money is put into the consolidated fund. There is no procedure or there is no formula that is provided for how specifically the people in Bungoma or Bungoma County will benefit from that revenue in proportion to what it has lost as a county asset. The money is put into the consolidated fund, and currently, what are we using the money in that fund to pay? We have a lot of debts as a government. The money is going to debts. So, if that company was to be used by future generations in that region, it means they have, from the moment it is privatized, they have lost out on their use. It is only you currently, or those proxies who will benefit from the privatization, that will actually benefit. The future generations, hatuwai kujua mambo yao itaenda namna gani. Si ndio?